speaking yet, that'd be great. Awesome. So, good evening and welcome to the latest session in Providence Housing Authority's Landlord series. I am Ainsley Cantorell. I'm the Strategic Initiatives Advisor for the PHA, and I will be your host this evening. Tonight, we will cover reasonable accommodations, discrimination, and the Human Rights Commission, and we will have tons of time at the end, hopefully, for questions and answers. So that's the plan. If you have any questions throughout the presentation, feel free to either raise your hand or add a question into the question and answer box. So at the bottom of your screens, there is a Q&A with the two little chat boxes, and that is where you would want to put your questions, and we will get back to you with answers or bring you in live to elaborate. We're going to try not to use that chat feature if we can. Since some of you may have to leave a bit early, I'm going to ask that when you leave the meet, just spend a couple of minutes completing the brief survey at the very end of the session. We're finding the feedback that you guys are giving us very helpful. It's allowing us to improve, to add new sessions as we continue our work with landlords. And then finally, just a quick reminder that these sessions are recorded and they will be available to you. We'll email you them at the end of the session, as well as post them on our YouTube page. With that, we're going to get started and jump right in. So Peter, can you move to the next slide, please? Oh, there we go. All right. Nope, there we go. So I apologize for the 2 or 3 of you who were here for the last session, but I would be remiss if I didn't share a little bit about why we're here and what we're doing. So I'm gonna just talk a little bit about the Providence Housing Authority first. So we are the largest affordable housing landlord in Rhode Island. We have over 2,600 affordable housing units in the city of Providence that we own and operate. We also administer over 2,700 vouchers on the private market, meaning that we give a voucher, Section 8 ticket to a resident or a participant who then takes it on the market to rent to somebody like yourselves and gets assistance with their rent through our programs. Finally, we have a special funding from Blue Cross Blue Shield of Rhode Island, and we have to give them a little bit of a shout out. They are providing the funding for us this year to assist us in working with voucher holders and to work with landlords, providing free webinars, monetary incentives. We got that money and so much more. And so that's really why we're here this evening. So thank you to Blue Cross for doing that. The other piece of this, if we can go on, is I do want to talk a little bit about what Section 8 is, because in just a minute, you're going to hear from Attorney Michael Crane, and Michael Crane is going to get into some of this in more detail and why it matters. But for those of you who may not be familiar with some of this, and I'll ask right now, Peter just popped it up on the screen and I appreciate that. If you are a Section 8 voucher landlord or not, we want to see who in the room has done this program before. So while I explain a little bit about the program, we ask you to fill out this poll. So while I'm jumping in, it is a federally funded program through HUD, Housing and Urban Development. It is administered locally by your city or town, and in Providence, that means the Providence Housing Authority. In order to be eligible for the program, the applicant would need to be at or below 50% of area median income. So let's talk about what that means. That means a family of 4 would make about $43,000 a year or less. Most of the people who apply for the Section 8 program and who are awarded vouchers are actually at 30% of the area median income. So a family of 4 would be making are earning less than $26,000 a year, and living off of that. So it's not a lot of income. It's certainly not enough to afford what you're seeing on the market right now, a typical, say, 3-bedroom apartment in the city. And the neat thing about the Section 8 program is that we're subsidizing the rent. So tenants don't have to pay more than 30% to 40% of their income on the rent. The housing authority puts in the remainder of that money that's owed to the landlord so that they can afford your amazing units. So what's really great is that the Section 8 program provides a guaranteed rental payment based on family size and income. We pay a portion of the rent directly to you. The tenant pays a portion, their portion, directly to you as well, so you get consistent payments. Another perk of the program is it has a very low eviction rate, and there's a lot of misconceptions about this program that we ended up actually adding a session later in the next couple of weeks to talk about this, but we will learn. Oh, and see, a lot of you are new to the program, which is awesome. We will learn a little bit more, and we'll do a deeper dive into this, but we actually have an average of 6 evictions a year for the past several years out of 2,700 participants. So very low eviction rates, a large pool of applicants right now on our waiting list to get one voucher. There are about 14,000 people waiting, and the waiting list is there, and it takes about 10 to 14 years to get through. So folks wait a really long time, and they value these. They're gold out there in the housing market if you're struggling. And so you wait a long time to qualify and to get this assistance. And so with that, we're going to turn it over to Attorney Michael Crane, who is working with the Housing Authority on this project. And he's going to talk a little bit more about private versus subsidized housing. Go ahead. Oops, muted. There we go.
Thank you, Ainsley. I follow rules. I muted it. Welcome, everybody. Thanks for joining tonight. This is a presentation that is ever evolving, and I've given a few times, more than a few times over the last couple of years. And as you'll see, there's one big case that has changed since the last time I gave this, which I think pretty much came out during this pandemic. So we will review all of that and get into that, and we'll take your questions. We're going to try to take questions as we go along as well. I think it helps in this presentation. Many of the times we wait till the end, but we will take questions during this presentation because there's a lot of information that we're about to throw at you. And basically what the bottom line comes down to is you'll realize don't discriminate. But let's get into the 2 types of landlords we're dealing with tonight. We're dealing with the property owners that receive subsidies and those that do not. Examples are a Section 8 voucher, the VOSH voucher, which is for veterans, low-income tax credit, home funds. You may also have project-based housing, which is supported by Section 8 vouchers. I see some of the participants are not, are part of project-based housing, but not in Providence, but this all still obviously applies to you. And the subsidy aspect obviously applies to you as well. And I think the one good thing about the CARES Act is it really defines those that are affected by and need to comply with VAWA regulations, and the private landlords that don't need to comply with VAWA regulations. I say that everybody that VAWA covers 99.9% of subsidized units. And the only reason I don't use 100% is because ultimately, some point in my life, someone would probably prove me wrong. So let's keep going.
Michael, just what is VAWA for folks who are not familiar?
Correct. Sorry, that's the Violence Against Women Act, is what that is. So if you have an individual in your unit, whether it's male or female, that is a victim of domestic violence, they're covered by VAWA, and certain protections come into place. So the legal resources that we rely on are federally the Fair Housing Act and the Americans with Disabilities Act. And then here in Rhode Island, which expands on the Fair Housing Act, is the Rhode Island Fair Housing Practices Act. Remember, Rhode Island, you cannot shrink what the federal government does, but you can always expand what the federal government does. So what's the definition of a disability? We turn to the American with Disabilities Act. It's an individual must have a disability or have a relationship or association with an individual with a disability. So you've got parent-child. Sometimes it can be child-grandparent, parent back up to their parents, maybe a niece or a nephew, or they may have legal guardianship of a child. The definition is a person who has a mental or physical impairment that substantially limits one or more life activity. That could be seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading. Everything's pretty much covered. Anxiety should probably be added to this list as well, with all of the anxiety issues that probably have come about in the pandemic, but also because the main question that comes out of reasonable accommodation and disabilities is always emotional support animals, which we'll get into later in the conversation. And remember, the disability includes persons with a history or a record of impairments, or a person who is perceived by others as having a disability. It's very important, the word perceived. If someone comes and speaks to you and they have a twitch, and I'll always go back to this example, they probably have anxiety, and that would be a disability that you can see and that you can understand what's going on. So you need to be very careful of saying, well, that person, didn't have they didn't tell me they had a disability, or they didn't provide me documentation. If you can tell that you think somebody has a disability, you need to rely on your gut instinct. Now, the Fair Housing Act was enacted to protect certain classes from being discriminated against. It prohibits adverse action being taken against persons based on their race, color, religion, nation of origin, sex, disability, familial status, pregnancy, or intention to adopt. If a tenant comes to you and says, we're going to adopt a child, they are going to expand their family. You cannot discriminate against them because they're not pregnant or because the adoption may not go through. It's still a protected class. It is clear under the law. And this requires you to treat everyone equally, have compassion, and provide reasonable accommodations as requested. So the Rhode Island Fair Housing Practices Act. Really, it says the same thing, but you'll see here, we highlighted in red the additional classes that are protected. You've got sexual orientation, gender identity or expression, military status, service members in the armed forces, country of ancestral origin, age, regardless of the fact that a tenant applicant or a member of the household is or has been or is threatened with being the victim of domestic abuse. That's different from VAWA. VAWA is protections, but this makes the victim of domestic abuse a protected class. So you have to remember that. And then, or that the tenant or applicant has obtained or sought or is seeking relief from any court for domestic abuse. Those are all protected classes, okay? Now, you can always evict somebody for not complying with a lease or for not paying their rent. So don't worry about that part. What is a reasonable accommodation? Very important to start here, the definition. It's a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with a disability to have an equal opportunity to use and enjoy a dwelling, including public and common use spaces. You could have a no pet policy, but if someone has a service animal or needs a service animal or an emotional support animal, you need to adjust your policy or practice to allow an animal. And we'll get into that a little bit more, but that's just a very simple explanation and example of what reasonable accommodation is. So what are the rights and obligations under federal law? They protect, obviously, against disability discrimination in housing, and they cover not only tenants and home seekers with disabilities, but also those who live or are associated with individuals with disabilities. So they're caretakers. And it prohibits housing providers from refusing residency to persons with disabilities or placing conditions on their residency because they require reasonable accommodations or modifications. A lot of times I'll get calls from people and you may believe what people say. I sometimes am still a little shocked by what people say, but I will have people call and say, someone called and their child has, an obvious disability, maybe ADHD, maybe some sort of verbal disability where they can only communicate through noises, and they'll say, I don't want to rent to them. How do I refuse rent the property to them? That's discrimination. So you would be very surprised how many times people will tell that tenant or an agent of that tenant they're not renting to them because of that child. They're not renting to them because they have an emotional support animal. They're not renting to them because they have a limp and if down the line may need a ramp. That's all discrimination. So reasonable accommodations, tenants must remain compliant with their lease or rental agreement. So as a landlord, your other rules and regulations still apply to them. They must pay their rent. They must respect their neighbor's right to peacefully enjoy the premises. They must park in assigned parking spots. They must care for their property. They must keep it clean. They must make sure that if there's an emergency, they notify you of the emergency. And your non-compliance letters should always be specific to that breach. Sometimes people will send generic non-compliance letters, which may hit on the disability, and now you've discriminated against that tenant, which is always an issue down the line. You should always have policies, plans, and procedures in place to help protect yourself. I tell everybody, obviously, if you're an owner living in a 3-family, this wouldn't apply to you. Reasonable accommodations may not apply to you if you're an owner in a 3-family. There is an exception there. But you should always have policy, plans, and procedures in place so that going forward, if someone approaches you with a reasonable accommodation request, how you're going to act and react and what changes you're going to make and how you're going to implement those changes. It just helps you down the line and helps keep everything organized. You'll know, okay, they're going to hand me paperwork. I need to keep that paperwork in a secure, confidential place. And you're going to know I have some sort of access to either a contractor or access to the proper documentation to allow for that change in policy to take place. They cannot minimize the threat of litigation, but they can bolster your defense if you do this. What does that mean? It means you can't hand the tenant something and say, well, I'm going to try, but you promised not to sue me just for trying. Really, what it does is it keeps all your paperwork in order, keeps you organized. So if someone did come and tries to file a lawsuit against you or a charge at the Human Rights Commission, you can say, no. Here's my paperwork. Here's everything I did. I took notes of every conversation with the tenant. I made sure everything was in writing. And I don't think I discriminated against them because I either never denied the reasonable accommodation or I allowed for the reasonable accommodation, but I needed to make some sort of, needed to provide some sort of alternative means to allow the accommodation to be implemented. And remember, the accommodation should not have a disparate impact on the tenant, meaning it can't implicitly discriminate against the tenant. This is, we're not going to get into the disparate impact, but this is one of the laws we're talking about. The latest presidential administration just put out a different definition of disparate impact. I don't know if it's going to stick or how long it'll be in place, but I would still tell people, rely on the old definition of disparate impact. Don't implicitly discriminate against tenants just because you think you can get away with it. It's the intent versus conduct argument that comes into play. It doesn't matter what your intent is. It matters what your conduct is. If your conduct is discriminatory, you will be found to have discriminated against the tenant. Even if you say I didn't mean to, or I was trying to be loving and caring because they were moving their child into my historically preserved building that has lead paint, and I told them not to do it because I didn't think it was safe for the child, that could be discrimination, and I've defended cases like that at the Human Rights Commission. I see we have a question here.
Yep, it's how do we get a tenant to clean their own snow? And I'm gonna hold that one until the end because that really is a little bit. You probably want to check out our leasing conversation from last week. Although I will turn that to disabilities and talk a little bit about if that is the policy you have in your lease and somebody says they can't do it. Michael, what would you say to that?
I would say if they have a disability, especially if it's a physical disability, you're going to have to amend your policy to provide snow removal for that tenant. And what's key to that as well is you can't just amend the policy and then increase that tenant's rent or charge the tenant for the snow removal. You're probably going to have to cover that charge because it's something that is an exterior issue, and that is the responsibility of the property owner in the long run. If it's an interior issue, let's say you need bars in a tub. Let's say you need to move a refrigerator so that they can move more freely around the kitchen. And just so you know, all of these examples are issues that I faced here in the office and defended at the Human Rights Commission. So I'm not just throwing out examples that I've read on the internet or Googled, 10 minutes ago before this presentation started. These are all issues we've had at the Human Rights Commission. But you would have to, if you're a private landlord and it's the interior and the exterior, pay for it. If it's the interior, the tenant pays for it. But if it's a subsidized landlord, you're always going to pay for the reasonable accommodation. It doesn't matter what it is. That's part of your agreement in accepting a subsidy. Okay, so we can move on.
Yep, and I see if it isn't a disability and they don't follow the rules, then you would issue a non-compliance letter.
Yes, you would issue a non-compliance letter to that
tenant. So hopefully that'll answer that, and we can dig a little deeper into that at the very end if you need to.
Correct. So policies and practices to consider. These are questions to ask yourself. If you're a company, are you required to have a reasonable accommodation policy? If you're an individual with 1 or 2 buildings, especially under 4 units, you're probably not. It's good to have. I mean, it's great to have. If a tenant says, hey, I need a reasonable accommodation, here, fill out all this paperwork so that all of your paperwork's in order. So if they ever file a discrimination charge against you at the Human Rights Commission or a complaint in Superior Court, you can say, no. Here's everything I asked for. Here's everything I did. I never denied it. All I wanted was the proper documentation, which is usually just a note from the doctor. That's all really that you can really truly rely on, but you at least have the information and you've requested the information and you can show whether the tenant was willing to work with you or not. So should you as a private landlord have a reasonable accommodation policy? Of course, you're going to ask me, and I'm always going to say yes. Whether you come up with one on your own or you see an attorney or you see, a property management specialist, that's up to you, but I would always have that. If you're if you're a company, you have to have a reasonable accommodation policy. You may be required to make a change in your rules, policies, and practices. We've gone over this. If the accommodation is necessary to give a disabled person equal use and enjoyment of a dwelling, and the change is not unreasonable. I can tell you right now, we will go over this. We may go over this numerous times. The changes are usually not unreasonable. And if they are, or if the building cannot support the change, then you're going to have to offer the tenant an alternative means to try to work through and figure out how you can accommodate the tenant and how the tenant can get to as close as possible equal use and enjoyment of the dwelling. And the first in time rule. The reason why that's here and the way it is because that's the newest case law that just came out. It was not here in Rhode Island. It was not here in New England, but it came out and said first in time, meaning if Ainsley lives in a building and she has horrible allergies and she's allergic to every animal in the world, and I move in and I need an emotional support animal, the landlord can deny my emotional support animal because Ainsley lived there first and has bad allergies. So that's been clarified in other areas for the law.
I am horribly allergic to chickens, by the way. No emotional support chickens allowed. So
there's a 4-part analysis here. Does the person have a disability? Obviously, if you can tell they have a disability, I always go back to the twitching because the twitching is related to the emotional support animal and the anxiety. So is it necessary for the person to use and enjoy the dwelling? It basically means live. So if someone needs an emotional support animal because they get nervous or anxious, there's a great video out there that shows a service dog and an emotional support dog that helps a lady who, when her anxiety gets bad, she causes physical harm to herself. You'll see how the dog helps this individual. So I think that accommodation is necessary, especially if you have a doctor's note, the doctor's notes, obviously anyone can go onto Google and get a $25 doctor's note. I'll tell you a funny story. I have a large property manager that I represent. He calls me about reasonable accommodations. We talk for a while and I tell him, listen, I said, anybody can go online and talk to a doctor for 2 minutes in Minnesota and get a doctor's note that says they need a reasonable accommodation. And he spent 20 minutes complaining about reasonable accommodations. He looks at me and goes, oh, I know, I got one for my wife so we could fly with our dog. So everybody knows you can go online and get it. But now those notes are being challenged. Why are they being challenged? People want to make sure they saw the doctor. People want to know how many times they saw the doctor. And they want to know if they saw the doctor live or if it was some sort of telephonic meeting, which right now with Zoom, it's a little harder to prove, but, or was it on the internet? Did you just pay $25 to get, or $50 to get that reasonable accommodation letter necessary? And then, is the accommodation related to the disability or disability related need? Obviously, if someone has anxiety, not obviously, but if someone has anxiety, they probably don't need bars and a tub. Those aren't related. There's no nexus, no connection between the disability and the reasonable accommodation. Go back to that, the one slide that we were just on. Whoop, we're all the way back. And then, is the accommodation reasonable? That means, is it reasonable for the building? Is it reasonable for the person? It's unreasonable if it imposes an undue financial burden or administrative burden, or requires a fundamental alteration in the nature of the housing provider's operation, not the building, but the operation. I'll tell you what, that undue financial burden or administrative burden, very difficult to overcome, especially if you're a company. You're not, there's a 90% chance you're not going to overcome that. But if it requires a fundamental alteration in the nature of your operation, then yes, you might be able to deny it, and you'll have more success than if it was an undue, than if you claim it was an undue financial burden.
So if I'm a small landlord, Michael, you know, I don't have a ton of money to put into these alterations. If it's on the exterior of the property, I still have to address it. If it's on the inside, I'm not.
Yeah, we're mainly talking about a ramp. I think that's
Okay.
that's the biggest concern, is a ramp and parking spaces. Why do I say parking spaces? I had a case, I'll tell you, it was one of the stranger cases. Lady filed a charge at the Human Rights Commission because there were 3 parking spaces. She wanted the parking space closest to the building because she claimed that she had a physical disability. Now, it turned out she was fighting with the tenants, fist fights, all this. She just wanted their parking space, and you know, she was busting their chops. But she filed a charge at the Human Rights Commission, and it was actually a really great case to learn from. So if you have parking, you don't necessarily have to go out and get a light. I guess you'd call it like a licensed parking spot, or identify it as a handicap spot. What you want to do is you want to identify and assign parking spaces to each individual unit. So if someone's already in that spot and someone moves in and says, I have a physical disability, I need the spot closest to the building, you're going to have to talk to the other tenant and say, listen, I need to provide them that reasonable accommodation is what I need to do. And so I'm going to have to label all the parking spots. I would think 9 times out of 10, it's not going to be a problem, but we do see it a problem. You're not discriminating if you're working on it and denying it. You would prevail. They could still file a charge at the Human Rights Commission. They could still file a complaint in court, but at least you've said, and you've logged everything, of course, taken great notes, and said, hey, listen, you can have this parking spot. I'm not denying it to you. Here are some examples of the accommodations. Waive pet fees. A pet is not an emotional support animal. An emotional support animal is not a pet. You need to memorize that and make sure that's ingrained in your brain. In addition, a service animal is not a pet. You cannot charge pet fees. You cannot charge a non-refundable pet deposit. You cannot do any of that. But you must waive, probably should waive any approval waiting periods you have. So if someone comes in and has an emotional support animal already, and it's obvious they have a disability, or they tell you that, you know, they're going to provide you with the proper notification, they already have the animal, you're going to want to waive. If you're going to say, listen, you can't move the dog in for 2 weeks, you're going to want to waive that approval waiting period. We've gone over the parking spaces. Recertification deadlines. They may need to get help with recertification. They may want to talk to their social worker. They may want to talk to a family member that they trust, because maybe because of their disability, it's some sort of mental or emotional disability, and there's someone they trust. They may have to move apartments during tenancy. I know all of the subsidized housing providers on here, and if I look at the participants, I recognize a lot of the names. You know, you've got to provide the reasonable accommodation when they need a new apartment. They may need to go from the 3rd floor to the 1st floor because of because of a disability. And you've got to provide it within a reasonable period of time. And the other thing you should know, if you're a company and you provide housing and you have waiting lists and you have a reasonable accommodation list, those two lists should be, you should have two different types. You should have one list that lists everybody, and then two separate lists: the reasonable accommodation list and your waiting list for housing. They should not be the same list, just so you know. It should identify that those reasonable accommodations separately. You should install handrails in bathtubs and showers. That's an easy one. Always do that. Allow the service or emotional support animals if you have a doctor's note. Waive occupancy limits. I can't tell you how many times people call me regarding occupancy limits and say they're going to exceed the occupancy limits. That's not for you to decide. That's for the city or town to decide. If the city or town comes along and says they're violating occupancy limits, then we act. But until then, I would not do it. You're just inviting yourself for discrimination. That's big on pregnancy. One of the biggest cases in Rhode Island out of Warwick and West Warwick. Couple has a 1-bedroom apartment, get pregnant, and the property manager says you're going to need a 2-bedroom apartment. That company fought that all the way to the Supreme Court and lost $3.2 million in discrimination because they told this family that was pregnant that they needed a second apartment, and they just didn't back off it at all. And alternative means. So if you can't provide the reasonable accommodation at that time, or you're not able to provide it for whatever reason, you need to provide the tenant alternative means, attempt to provide the tenant alternative means and work with them for those alternative means. If you're doing that, you're not denying the reasonable accommodation, you're working with them. That's HUD requires alternative means.
Michael, if I'm a small landlord and I want to provide a waiver, do I need to do that in writing, or how should I back that up?
What do you mean
like
by
if I'm waiving, if you go back to that last slide there, if I'm waiving a pet fee, or if I'm waiving an approval waiting period, or something that I would do for my other tenants so that they don't get upset with me, do I put that in? What do I have to do to document that?
Yeah, but the other tenants can't get upset because you just tell them they didn't move a pet in. So that's all you would say. You wouldn't say any more because you don't want to reveal any private information under HIPAA, but you can just say, listen, and most people won't tell the other tenants that the pet fees were waived because it's not a pet. They'll tell the tenants, oh, it's not a pet, it's an emotional support animal. So they'll save you that. But yes, to have everything in writing and have in their file is really good. And then your defenses. Intent versus conduct, not really a defense. They'll always fall on what was the conduct. Standing. Does the individual have standing to file a charge against you or sue you? You can always say it was an undue burden to provide the reasonable accommodation, meaning you just couldn't do it. It was just too burdensome for the project, for the family, or for the unit, or that you live there. It would fundamentally alter the premises. It was unreasonable, or it was a direct threat. And go to the next slide. So,
Michael,
specific animal.
I just want to share a question.
Oh yeah, sorry.
There's a question about, you mentioned separate like having a separate list between your waiting list and your reasonable accommodation list. Can you just explain that again?
So yeah, so let me actually. So HUD is at the Human Rights Commission. I have a few cases right now where they ask for the lists for reasonable accommodations versus routine transfers within a project. So if someone needs a different unit because they have children, they've had some children and they're waiting for a unit to open, or let's say they've lost or their children have moved out, they want to go down to a 1-bedroom, or someone comes along and says, I need a reasonable accommodation. Those two lists should be separate. And the reason why I say 3 lists is because everybody always puts them on one list, which is fine, but you're going to want to go off the 2 separate lists is what you're going to want to do. And that's what's best for your project, is to make sure you have those 2 separate lists. If you don't have those 2 separate lists, that could be considered discrimination. So does that help? Okay, great.
hold on, let me just, I'm gonna just see if the person that asked the question wanted to say anything on that.
Yep.
Magda, are you there?
Yeah, that's clear. Thank you.
Okay, great. Thanks, Magda. So now the basis for denial exclusion, the specific animal poses a direct threat. I would think the allergy example that I gave earlier comes into play. Also, if the animal is uncontrollable. So let's just use everyone's favorite, the pit bull. So everybody wants to move a pit bull. I think probably, I'm guessing here completely, but I would guess that 60% of pit bulls in the world now are emotional support animals so that people can keep them. But if that pit bull's untrained or growls, barks, jumps at people, then it would pose a direct threat. So it's an undue financial and administrative burden. So here you see, I combine them. I say, listen, if it's a financial and administrative burden, it just isn't going to work. You can fall back on that. Fundamental alteration, obviously, to the premises, and you just can't alter the premises, meaning you can't move a stairwell. There's absolutely no way to install bars in a shower. I wouldn't do that, but I've had people ask. But those types of fundamental alterations are defenses that people use. And then ADA compliance. I always like to look this up and I forgot. I think it's 1988. Any building before 1988, you're going to get away with some ADA compliance defenses. So don't quote me on 1988, but there is a year. I'm pretty sure it's either, I want to say 88 or 92, but I'm going to go with 88. Be careful with that. All right, so tips. I think I've hit on this a little bit, but let's just be real clear. Ask for everything in writing except for the obvious disabilities. All right, so someone comes in, they're blind, or they walk, they obviously have an issue with the way they're walking and they're using a miniature horse or a very large dog for balance. That's an obvious disability. Let's not sit there and hammer them for reasonable accommodation paperwork. Just don't. Make sure they give it to you for sure. But, if they say, oh, I've got to get it from my doctor's delaying it, give them 2 to 3 weeks, even 4 weeks. Don't after a week start screaming and yelling at them. That's never going to end well. Always review dwelling availability. So this is for larger projects. If you say, oh, I don't have a unit available that you're looking for, go through your dwellings that are available or that may be coming available and say, listen, we have these 3 units that are becoming available. Would any of those work for you? And that's also analyzing other accommodations that could work. So let's say you can't have an emotional support animal because the person has allergies. Maybe talk to the person with allergies and say, does a hypoallergenic dog work? And then you could tell the person, listen, you don't have a dog yet. What about a hypoallergenic dog? And then offer alternative means. Obviously, a different way to work around the reasonable accommodation and other reasonable accommodations that you could possibly provide to the tenant.
What if the animal is, what animals are considered service animals?
Well,
I
that's a great question.
jokingly added chicken to the list, but I mean, is that a service animal?
Well, what was, I think it was the fires in Arizona. They were, someone claimed that a squirrel was their service animal after the fires because the squirrel and that individual bonded during the fires. So if you type in reasonable accommodation or emotional support animal squirrel, you'll see. They're starting to rein them in. Wild animals are not emotional support animals or service animals. But miniature horses are service animals. They help individuals walk. But snakes, that's borderline, but people have snakes as pets. So it all depends on the state you're in, the legal jurisdiction you're in. But I would be careful what you're going to deny. I would speak to an attorney first. You have a couple days. You don't want to sit on it to deny, but most of the biggest one people want to do is dogs over 50 pounds or dangerous breeds. Doberman Pinscher, Pit Bull, German Shepherds. Those can be considered dangerous breeds. So you want to make sure that you don't deny them as emotional support animals right off the bat. You want to make sure that they're actually a dangerous animal, not trained. You could always make sure that these animals are licensed, that they're registered with the city or town you're in, that they've gotten all of their required shots. You can make sure that the animals are up to date with their vaccines for the safety of the other tenants in the building. All right, the Rhode Island Commission for Human Rights. I put this up here because tenants, they Google now and they speak to people, and they're very quick to file what's called a charge to the Human Rights Commission. Basically, they intake, investigate, and settle discrimination charges. HUD is intimately involved. That's how we knew about this new list thing, where the lists for transfers and reasonable accommodations need to be separate. It's not to be taken lightly. Charges are filed every day. But you have to be careful. This is how we found out also that you need to offer the alternative means on your reasonable accommodation request application. So you need to make sure that they're on there. The Human Rights Commission is good at what they do. They will investigate. They're not just going to come down against the landlord. We're successful over there. So that's not something that you need to worry about, but it does cost you time and money. And I can tell you there is blatant discrimination that I've dealt with over there with clients where, they've just had to, go over there and resolve and settle a matter. And we get out, we do what we need to do, and the parties go their separate ways. But it is something to worry about and be concerned with if you want to discriminate. I mean, that's unfortunately the way it is.
I have two questions for you, Michael. One, I only have one unit that I rent to. Do I have to have a form on hand in case a tenant needs? I mean, what do I have to have as far as the burden of paperwork and documentation?
So you can have a form. You're not required to have a form at all in your situation. You can have one just to keep notes if something was to ever happen, so that you keep a good paper trail of all of your communications and interactions with that tenant. And that way, if that tenant was to ever file a charge, you would be able to show all the actions that you took to not discriminate. Now, I have people that, will email or say you shouldn't have the child here for X, Y, and Z reasons. And no matter how good your paperwork is or your paper trail is, doesn't matter. But it does help you in the long run to have a good paper trail.
I also have a tenant who is insisting on allowing that they be allowed to smoke. They're saying that's medical.
So great question. Medical marijuana is also, you don't have to smoke for medical marijuana. It comes in a, what do they call them? Gummies, chewables, edible. There you go. Sorry. I showed my innocence. But it comes in an edible form. If they want to smoke, they can go outside and go 50 feet from the building and smoke. You're not discriminating against them because there is an alternative mean. They can use edibles. It doesn't have to be smoking.
And what about addiction?
That's almost a protected class. It is a protected class. So you're not going to want to discriminate against somebody for addiction.
But you can still enforce the lease that.
Yeah, for better or for worse, you can enforce the lease, and many individuals with addiction end up becoming in noncompliance with the lease or failing to pay their rent because of the addiction. So many of those cases resolve that way. Not a great way to resolve a case, of course, if somebody has an addiction, because it's a mental health issue. So that's where they're protected.
I want to just throw in another question, or two related questions. There's one from an attendee saying, what is the occupancy limit for a 3-bedroom apartment? And then there was a question, and I think this may be in the quiz, but I'll just bring it up now. Rennie Marin asks, can you give an example of how to resolve or offer a solution to that overcrowding issue that you gave before? So is there anything that you should do, or another way that you can address that?
Yeah, so the overcrowding issue is always a big one. Normally that involves unauthorized boarders and lodgers. So a non-compliance letter for anyone that doesn't live there, unauthorized boarder and lodger. You're going to have the names of the individuals there. to really be successful in the long run. It's helpful for the case, and it's helpful to know who to remove from the property. If it's a family, and there's, you know, that many people inside the unit, I think at some point, I think if you've got, you know, it's, you know, really, let's say you've got 2 units and you've got 3 kids. You probably have a baby sleeping with the parents and 2 children in the other room. The family is most likely going to get away with that, depending on, you know, what's going on in the situations. Don't fall back on the Section 8 rules for what is needed in a bedroom to tell them, especially, you know, if they're not on Section 8, you know, or they might be in violation of their Section 8, you know, or they could be in violation of I see the occupancy limit question here. You know, it might be something you talk to the town about. Talk to the town and say, hey, listen, this is the problem I've got. Excuse me, how do you feel about it? You know, that is, you know, something you can do. And if they've never complained to you about any building issues, if they have not filed you know, a restraining order against you, or they filed a charge with the Human Rights Commission, usually, you know, at some point, there's going to be a way to terminate their tenancy, whether it's a straight termination for no reason because the lease is up, whether it's non-payment, or whether they're disturbing their neighbor's rights to peacefully enjoy the premises, which happens all the time with overcrowding. That would how we would do that as well. So we kind of work on an end around. And usually when it's overcrowding in that situation, we're not talking about children. We're talking about groups of individuals who have just started to overtake an apartment, and everyone's moving in. If it's a situation with children, you know, and especially if it's a subsidized housing provider or you're providing some sort of subsidy, then usually we can find them a new unit as well. And we would talk to them like, hey, listen, we need to find you a new unit because you're in violation of the federal regulations.
Okay, and in terms of, I don't know if this is part of the state building code or a town by town type of thing. Is there, I know this is a little bit off the topic, but is there a kind of limited to the number of people that you can allow to rent like a 3-bedroom apartment? I think that's the question that they were.
There is, if you, so
It's dependent
anyone-
though on location.
it's really dependent on the city or town. They're all pretty close, with their, so just know this, under the age of 1 year is not considered an occupant. So, and as I talk to you guys, I'm trying to, I know exactly.
It's like a lap child on an airplane. You don't get to count those babies.
Exactly.
And I believe it's by square foot. It's a pretty complicated, there's a formula for how much space versus how many rooms, and how many people are allowed in each room. So it's really a good thing to just confirm with your city or town to make sure with their building department.
It is, yes. So we can, if I get a second, I'll go through my emails because I just did a whole, for Pawtucket. I have all the occupancy limits for Pawtucket. So, but we can go on to the next slide, and I'll take a second at the end to look that up so people can have kind of a general consensus of what to expect when it comes to occupancy limits. So what does the Human Rights Commission look for? Intent versus conduct. There it is again. They're not real concerned about intent versus conduct. It's really your conduct. I always go back to the one case I had where they put it in writing. You probably shouldn't have your child living here. Because it's a building protected by the Historical Preservation Society of our city or town, and there's lead paint. And they did not have the funds to correct all the lead paint issues in the house. They'd owned the house forever. It was a beautiful house, and it was really going to change the composition of the house. But they didn't say that. They just said, you cannot have your child live here. And the saddest part about the case was they were copy and pasted the language they used stating about the child from another attorney who had given them that language, feeling that the conduct was not discriminatory, but it doesn't matter. So you also have to look at the severity of the discrimination, because really, if you've discriminated, what's the severity, meaning how much you're going to pay? Because you can pay to get out of it real quick. The cost of it, you know, and try to pay less than what the cost of the attorney's fees are going to be, but you're going to want to get out of it real quick. What are your policies and protocols in place? Meaning if you're a company, if you're a subsidized housing provider, if you're project-based housing and you don't have policies and protocols, you're going to get in more trouble than someone who does. And if your policy and protocols are missing something required by HUD, that's going to get you in trouble. If you have everything in place, that'll just help going forward. And then what training in place do you have? Where have you sent your employees? What have they watched? What have they seen? What certifications do they have to try to ensure that they don't discriminate against tenants and that they're acting appropriately under the Fair Housing Act and the Rhode Island Fair Housing Act? And the liability is always on the property owners, the managers, any agents. So if you send your maintenance worker over there and the maintenance worker says something discriminatory, that's coming back to the property owner or manager.
So does this apply even before you get to tenancy with somebody? Are
Yes.
some of these
If
rules
you're-
and regulations?
Yeah, if you're negotiating with somebody under the Fair Housing Act, if you deny them housing for one of these reasons, then you've discriminated against them.
Oh,
So you have to be very careful.
but I could put an ad up. I mean, if my unit's not is you know, say a 1-bedroom, I could say in my ad that it's, you know, best for, I mean,
No,
that it's for 2
That's
people.
discriminatory. The intent behind that is to ensure, they would say the intent behind that is to ensure that no children move in.
Oh,
So you don't want to put anything in ad. You just want to advertise the actual unit. I have a 1-bedroom for rent. I always tell people in that situation, if you have a 1-bedroom and you have a family of, you know, 5, 6, 7 show up, let's use the large number, you know, or even 4, and you're like, it's a 300 square foot unit. You're going to want to make sure you have lots of applicants because you're going to want to choose. And when someone comes, just say, listen, we're making a decision within 2 weeks, or this is what we're doing. But give yourself a window. And, you know, sometimes you're doing a better, whether, even though you could be charged with discrimination, you're probably doing, you might be benefiting them in one way, and another way you may not be, because they may need housing really, really bad. And this might be the only way they can get housing. But at the same time, it may be something that benefits the other tenants in your building as well. It's not an easy situation by any means. I did see a question, but
Yes, I'm going to let the person who put in the question have a chance to just explain it. Hold on one second. Rennie, are you there? Okay, they may not be able
Renee?
to unmute. So I could just read what the question was.
I think I see it here. The female in the single room occupancy studio,
Yes.
less than 3 years, 3 times, 2 children living with her already and pregnant with a 3rd. You know, I know that he's a subsidized housing provider. So at that point, what I would say is, you know, we need to fall back on the federal regs overseeing that unit. And we need to speak to that individual about how they're, you know, we're in violation of the federal regs, and that we need to work with that unit to identify a unit that puts them in that where they can still receive their subsidy and puts them in compliance with federal regs for everybody involved. Because at some point HUD could come on down for you, come down on you for that. And then, you know, how do you deal with HUD if HUD dings you? So you want to show HUD that you're working with this person to find them the appropriate unit, whether it's there, whether you're helping them apply at other units, whatever it may be. You want to work with her to show her, to assist her with obtaining the proper housing for her children. She's already in subsidized housing. So that's, as we heard, the waiting lists, everything going on, that's 99% of the battle. Now let's work with her to find her some sort of alternative means to provide housing for her children that is proper, especially under the federal guidelines. And I'm sure Donna or Yvonne or Caroline can maybe even speak to that as well. If they heard of someone who was in a single room occupancy unit, you know, a single one with 3 children, that might be somebody that comes on their radar that they want to work with as well.
There's a question about somebody purchased a property 3 months ago. They don't know if it has lead paint. And we're going to do a separate another training on November 16th that talks about healthy housing and the inspection process. And we're going to have a presentation from the Childhood-Led Action Project. So I don't want to get into that here today, but we can just say that I can just tell you in Rhode Island, unless you are in an owner-occupant 3-family, again, that you are required to have your property be inspected by a lead inspector and not be totally lead free, but be lead safe.
Yes.
So you can contact us for more information on that or come to the next training.
Yep. And I'm looking here, are there fees for service animals? If you charge a fee for a service animal, you discriminated against somebody or an emotional support animal. You cannot charge those fees. You can charge you can't even charge the non-refundable deposit. That is part of a reasonable accommodation. That would be your change in your policy or procedure, is to waive those fees.
And we also have one that's asking, can you just deny every high-risk prospect based on credit alone? So when you are looking at tenants, is that why you said you needed a big pool of, you wanted to have a pool of applicants so that you could deny?
So the problem with that is you're including good tenants in that question. So the short answer is absolutely not. Because if you denied everybody and a smart attorney comes along, he's going to, in discovery, say, hey, show me all of the X individuals. So maybe it's a family with 2 children that you provided housing to. Show me all that applied and all that you granted housing to. And if it's 100 people applied and 100 people were denied, you're obviously discriminating. You'll get caught red-handed doing that. So if so you have to be careful. I think that's the best answer to give on that. There are other options for you, but I would not outright deny everybody for that reason. Because if it's an outright denial of 100% and somebody ever challenges or questions that, then you're going to be in trouble.
And I will say that perhaps a Section 8 tenant might be right for you. Their credit score may not be there, but the subsidy would certainly help make sure that that rent was paid consistently and on time. And a lot of folks we've seen kind of don't really think about how somebody with a subsidy will be bringing consistent rent, even though some of those unsightly things may have been in the past. They're there because they couldn't afford the unit and they waited that 10 years to get the assistance. So just a little personal plug. We'll be talking about it another session next week about why Section 8 and an intro to kind of Section 8, just to put that out there. All right, let's move on to the next slide because I don't see any other questions right now. So we are going to play the discrimination game. So here are the rules of the game. I was inspired last night by watching the remake of Supermarket Sweep and all the new game shows that are coming out now that new TV is back on. So the rules are, we're going to give you some scenarios. We're going to pop them up on the screen. We'll talk you through them. We're going to have you answer the poll, and then we're going to review the situations together. And Michael is going to be very generous in answering our questions about each of the scenarios. Does everyone understand? Raise your hand. Hit that raise your hand button if you understand. Show me that you understand. 3, 4, 5. It seems pretty easy. I think I see folks are engaged. They're awake. It's the only way I can see that you're awake right now. All right, so we're going to go into scenario 1, please. All right, scenario number 1. Yes, right there. Thank you. So in scenario number 1, you have a lovely couple who is renting a studio apartment from you. They're in the process of adopting a child. They inform you as their landlord that there will be property inspections of their unit, and that's how you find out they're in the adoption process. So the manager, you tell them that they're going to be over the occupancy limits for the city or town if they bring that child into the home, and you tell them that they're going to have to move to a bigger unit. Is this discrimination? All right, everyone, we want you to dial into that poll. You want to answer yes, this is discrimination. no, this is not discrimination, or it's okay to admit you're just not sure. And give everyone a couple of minutes to think about this. Again, you've got a couple in a studio apartment looking to adopt, and you've just told them that will be over the occupancy limits and will need to move to a different unit. All right. Peter, how does that response rate look? All right. So, Michael, what's the answer?
Well, I would think that we've given the example of one of the worst cases in the history of Rhode Island being very similar to this. So the answer is yes. So I'm a little disappointed on the nose. Maybe we didn't listen today. No, I'm kidding. So no, it's difficult, especially if you don't know if you're a property manager or, you know, if you've got your own unit. You know, it's not up for you to enforce occupancy limits. It's not up for you to discriminate against someone who's pregnant or for their familial status. Those are protected classes. This is a classic case of discriminating against a protected class, which is a growing family. And not only that, anyone under the age of 1 is not considered an occupant as well. So you've got that issue as well. So you've successfully discriminated under the Fair Housing Act and the Rhode Island Fair Housing Act. So congratulations to that landlord. They're going to be in a lot of trouble. I've defended many cases at the Human Rights Commission with a very similar scenario. I always tell people, the worst part about being a landlord is you don't realize it's a business. You don't realize how emotional it gets, and you don't realize how difficult it is to just keep your mouth shut, especially in certain situations like this. So what I would say is it is discrimination, and don't say anything, and you work with what the hand you've been dealt, and there's nothing you can do at that point. So don't bring up anything to them.
All right. So let's go on to scenario number 2. Look at these precious little angels. If they're anything like my precious little angels, your prospective tenant goes to show the property, is coming to look at your property. They have a toddler who is very, let's say, rambunctious. When they toured the site, kids jumping all around like a toddler, 2-3 years old, running amok, playing with the toys, making loud noises. After they leave, your other tenants share that if you rent to them, okay, and that kid comes in, they are going to move out. So you think that you're going to deny them renting the unit based on the objections of those other tenants. So that's the reason you're not going to rent to them. Is this discrimination? Yes, no, maybe so.
And you've also sent an email to them denying their tenancy because the other tenants would move out if they moved in because of their child.
And as a parent, I am completely insulted and hurt because you're judging me on my parenting skills. And we were just having a really bad day. We didn't have a nap. All right, results are in. Discrimination. Michael?
So this, hold on, sorry. Well, yeah, 90. All right, we're getting the hang of it. Yes, it is discrimination, clear discrimination. I had this exact case at the Human Rights Commission, and I can tell you that it was one of those to get out of it. We wrote a check to the tenant, to the prospective tenant. It was a very difficult situation. The prospective tenant was very difficult. And the 2 individuals that lived in the building, and this was not a mitigating factor, both actually, and this is way pre-COVID, worked from home. They were on the phone a lot, and they were in their computer on meetings a lot. But that did not matter. They were 2 very good tenants, and that did not matter. It is discrimination. I can't say it enough. the less is better. Just either deny or allow the person to be there or walk away. If it's a current tenant, you have to walk away. I had one person email me, a property manager emailed me about a possible situation, and the property owner said, kids aren't getting in there because they're going to flush toys down the toilet. I don't want that. Well, that's difficult. That's discrimination. That's not a reason to deny housing to a family with children. They're a protected class.
Michael, just going to go back quickly to a question that came up with the prior scenario of family. I think it was related to that. There was a question of, okay, you can't deny them, but when and I guess I would presume this means when the family size increases, can you raise their rent?
A lot of people want to raise the rent. I would do it in due course, meaning if you're on the year. I have had cases that have settled at the Human Rights Commission because the rent was raised, because there was going to be additional water use. The Human Rights Commission considers it discrimination. If it's a baby, I just wouldn't do it. But I've had it where they've moved teenage kids in, and I think there's an argument to be made there. Most of my clients just end up offering some form of settlement, which is close to, which saves them attorney's fees and saves them issues on the end. So I've never litigated it all the way through. I don't think it's discrimination in certain scenarios. I think in others it would be, but the safest way to do it is just in due course. Every year you're going to raise the rent.
That's a really great point. Thank you.
A couple of people with their hands raised, so I'm going to just call on and see if they have a question. The first one is she took for hers down. The first one is going to be Kristen Caproni. You have to unmute.
Are you sure it wasn't from earlier when I asked folks to raise their hand if they understood the rules?
It could be. Kristen,
I think it might have been from earlier. That's what people are saying.
Okay. All right. Kristen, if you don't have a question, I'm gonna. Okay. If anybody does have a question, you can hit the raise hand, or if you're on the phone, you can press *9 as well.
We do have a question in the chat right now before we go to our next example. Michael, are there any examples that you can provide of where the landlord was discriminated against?
I have never, yes, it's never resulted in a charge to the Human Rights Commission. But all of the obvious, they come in and, use racially insensitive comments towards property managers, they make fun of their sexual orientation. I have a big one making fun of sexual orientation right now. Or they make fun of them for their physical disability or physical looks or physical impairments. The question is, the follow-up question is, but why? Great question. Two reasons. One is many of my clients are subsidized housing providers. So the individual making the comment has mental health issues or some form of disability. Or number two, tenants, the tenants don't have the financial wherewithal to defend themselves or compensate the property manager if the property manager was to prevail, if it went to trial or a hearing, or to resolve the case. But I think mainly the first part is more it's more mental health issues, and more it's subsidized housing, so you're dealing with people with disabilities and mental health issues, and it's unfortunate. I'm not saying it's right, but it is the way it is. And when people sue people, what do they want? And what's the cold hard truth of what people want? If I was to sue Ainsley, people want money.
I don't have any.
And when you're suing people, they're all judgment proof, and they're not going to have money. So that's what it is.
Awesome. Let's get into scenario number 3. I might not have money, but I do have a support chicken that I am allergic to. So the individual is already living in your unit. They have 2 small dogs, which you have allowed. They're listed as pets in the lease. The lease has a clause that forbids dangerous breeds. Now, they've come to you because they would like to purchase a pit bull and list it as an emotional support animal. You say no. Is this discrimination? Let's give everyone a minute. And Peter, how we doing? Are there a lot of answers in?
We have 6 votes. I can up 7, 8.
Get those votes in. Final answers.
This
Here we
is
go.
the one clear cut one, so it's not real clear cut.
Yeah, this one might be a trick. I feel like there's a trick in here somewhere. Okay, we have 50%. So about half of you say yes, it's discrimination to say they can't have a pit bull. Some of you said no, and a lot of you are unsure. I would be unsure. This is a tricky one. Michael, explain why this is a trick.
So it's probably the unsure who's right here. I would probably say maybe. It depends. For many reasons. One is, are they just trying to get around your pet policy? They already have 2 dogs. You know, I think at some point it's a reasonable question to say, are one of those dogs an emotional support animal? Are they just trying to use do they just want a pit bull? And they're just using the emotional support animal avenue to obtain that pit bull. I can tell you, I would say 75% of the time that the answer to that is yes. They're just trying to get a pit bull and they just want a pit bull to be with them. For the facts that I see behind the scenes, to litigate it would cost tens of thousands of dollars, so nobody wants to do it. But I would argue that this is not discrimination if you deny the pit bull. Obviously, I represent landlords, but I would say it's not discrimination. There's absolutely no need for that person to have a 3rd dog at that point, and that they're just trying to get around your policies and procedures of your property management of the property that you manage.
Now, if the dog, say, was some kind of specialized, trained...
That's different. If it's a service animal and it's trained, then you're going to have a problem. Then your answer should probably, yes, I'll amend my policy.
Okay.
Absolutely.
All right.
Because you could have been disabled. Let's say you got disabled after getting the 2 dogs and now you need a service animal, a true service animal. That would be a reason to amend the policy for the pit bull.
Well, what if I have 2 chihuahuas and they're nasty and they're not nice and they don't cuddle?
Then they're dangerous dogs and you could probably send a non-compliance letter to get rid of them. Well, wouldn't even have to be that. You could just allow them to relieve themselves in whatever way they relieve themselves all over the interior of the unit and the common areas. That's a non-compliance.
So there are a lot of nuances to discrimination, and there's not always a cut and dry answer. And in those situations, what should somebody do, Michael?
I think we talked about it. You want to make sure that you keep good notes, everything in writing, consult an attorney, and just make sure that you have open lines of communications. If you don't think you can provide the reasonable accommodation, maybe alternative means, which could also be letting somebody out of the lease. Don't let that be your first option. But if you've explored every option and the tenant you might say, hey, listen, do you want to get out of your lease? Maybe I'll waive a month's rent. I'll just return your security deposit if you find a place, but work with them to get to that.
All right, we're going to do scenario number 4 because I'm mindful of the time and we are almost at time. You have an individual who has lived in a unit for 5 years. They have requested that handlebars be installed in that beautiful bathroom shower. You approve the request, but stipulate that the tenant must pay for the change. Is that discrimination? Making them pay for the change.
Let's give a hint. There better be there's 2 different answers here.
So it's another trick. So we're seeing if we're keeping you on your toes tonight, people. All right, let's get everyone's answers in. I don't have any Jeopardy music. I need Jeopardy music. All right, Peter, who's got this? Ooh, we've got some yeses. We've got some no's. No unsure's on this. Everyone seems to be pretty clear about their opinions.
So let's have all the subsidized housing providers raise their hands, and then we can see who's right and who's wrong. Anyone who provides a subsidy, raise your hand.
All right, we got 3, 2, 3. Somebody doesn't want to admit that they're a subsidized housing provider. They thought better of it. We got about 3 of our 13 participants.
All right, that's okay. So, no one else? All right. So if you provide a subsidy, you need to pay for it. If you're a private landlord, the tenant needs to pay for it.
But if I have a tenant who can't afford to put this in and say
so that's a great question. This was a great discrimination case I had at the Human Rights Commission. Tenant was a veteran and Operation Stand Down secured a grant to pay for this person's rehab to a bathroom because it was a private landlord. So the person had to pay for it. The Operation Stand Down provided an agreement to the landlord, and the agreement basically said the Operation Stand Down is going to pay for everything to get the bathroom remodeled. But once the contractor walked off site, right when the remodeling was done, the landlord was responsible for everything. So that meant the contractor, the way it was written, did not even have to test the toilet to make sure that the toilet flushed properly. So what if the contractor walks off site and the toilet doesn't flush properly? This was a $2,500 rehab to the bathroom. So it wasn't simple by any means. The tenant could then call the building inspector, and the building inspector could say, you don't have a properly working bathroom. Or the tenant could file a restraining order and say, I don't have a properly working bathroom. And then the landlord could be responsible for putting the tenant up in a hotel because they don't have a bathroom. So they can't live in their apartment properly. So we told Operation Stand Down, we approved the reasonable accommodation, but the contractor has to be on hook to make sure this toilet works and make sure everything works. And we don't want them to walk out and 48 hours later, the toilet doesn't work and we're on the hook for it. Operation Stand Down said, we can't find a contractor that would agree to that. So there was a charge filed against my client. We went to the Human Rights Commission and we prevailed because we did not discriminate against this person. We asked them to find a contractor. They went to one contractor, didn't go to anyone else. And that was it, and said, we discriminated because we didn't provide the reasonable accommodation. We did, we allowed it, but we didn't want to take responsibility for it within 24 hours. Now, if you flush the toilet and the pipes burst in the wall, and we told the individual this, then that's our fault. We got to fix the pipes in the wall. All we're saying is the toilet's got to get to the pipes in the wall. And that's how that went.
One quick question that somebody typed in the Q&A, and I think you kind of addressed this before, but can you just explain again how if you are an owner occupant, what changes in terms of the discrimination?
So if you're a 3 or 4 unit, I mean, providing the reasonable accommodation. I mean, if it's an emotional support animal, you might want to do it. But if it's a major fix to the building or major change to the building, or an undue burden, I think the standard is going to be a little lower. You probably won't have to provide it. Excuse me. So you're protected in that sense.
Great. So we know we've covered a whole lot of information tonight about reasonable accommodations and discrimination. We did want to provide Michael's contact information. He is available for follow-up questions, or if you would like to put him, utilize his legal services. His information is here. Michael, you're on Facebook too, right?
Yeah, I do have a business page on Facebook, yes.
Okay, so you can look him up. All right. So I really want to thank Michael for being here tonight and for sharing all of this amazing information. Thank you
for having me.
so much. Oh, we got somebody saying they can't wait to see you in court.
Uh-oh.
I think they were joking. I hope so.
I know him. Yeah, that one's fine.
Yeah, so I do want to just talk a little bit. We have a couple minutes left, and as we end the session, I do want to say that we have a couple of sessions coming up. If you enjoyed today's session, we do have an intro to Section 8 coming up for those who may not be aware, who have never leased a Section 8 before, never considered it, or have considered it and had questions. This is a great session for you, and that's coming up November 5th, which is next Thursday. We have another one after that on the inspection process and on healthy housing that'll cover lead, it'll cover occupancy, some of the requirements and basic building code stuff. So that's on November 16th. And that is also going to cover how to pay for some of that work as a small mom and pop landlord who may not have the means for a big renovation. So there are some low cost ways that you can get that covered, some free ways to get that covered. And we're going to talk about that then. So you'll want to join in for that one. And then there's more coming in the spring. So like I said, if you have feedback, have some topics you want us to cover, please give us that feedback. And when your session closes and you leave the session, take that survey. I also want to mention that if you have a free, an unoccupied unit and you are looking for a tenant, we have some amazing people ready to go, already vetted. And we are giving cash out the door, cash incentives, $500. $500 if you're leasing to one of our participants right now that are pre-vetted, ready to roll, our mainstream and VASH participants. We also are giving folks another $500 if they have never leased to the PHA before and with a voucher in our Section 8 program, and they've decided to sign a one-year lease with one of our possible tenants. And finally, another $500 if you have a unit in one of our neighborhoods of opportunity. There's a lovely map there. It's those shaded areas, shaded in orange, and we have more information on those. So it's up to $1,000 in bonus money, cold hard cash, if you have a vacant unit and you're willing to work with a Section 8 participant. So a lot of really exciting things going on right now. If you'd like to learn more about those incentives, about the sessions coming up, if you have follow-up questions from tonight's session, please go to www.provhousing.org/landlord. You can also contact our amazing Accessing Home AmeriCorps member, Caroline, who is working with us to field all of our landlord questions and acting as our landlord liaison. You can also follow us on social media, Twitter, Instagram, and Facebook at Prov Housing for updates and information. We're always posting new stuff and cross-posting some of the great stuff Michael's got going on, those resources. So with that, if there are no more questions, no more questions. Thank you all for joining us this evening. Thank you, Michael. Thank you to Donna,
Thank you, Ainsley,
Yvonne,
for having me.
Caroline, and Peter from our staff. We really appreciate